that, I will open the floor to you.
Do you want to put it on?
Hello, bonjour. Merci d'avoir pris le temps de...
Thank you for taking the time to participate in this media advisory so we can talk about one of the most significant issues facing human rights in Canada.
Director of the International Commission of Jurists Canada. Together with the three esteemed speakers in front of us today, we would like to present the key points from a major pan-Canadian event which took place on November 29th in three cities of Canada: Ottawa, Montreal, Edmonton, and online. The one-day-long event, titled A Call to Action, Fundamental Rights and the Notwithstanding Clause, was hosted by a group of organizations from across Canada, including the International Commission of Jurists Canada, La Faculté de Droit, Université de Montréal, the Center for Constitutional Studies at the University of Alberta, the University of Ottawa's Faculty of Law, and the U-Ottawa Professional Development Institute. The aim of the event was to bring together a diverse group of scholars, lawyers, journalists, and others to discuss the challenges posed by the evolving practice around the Notwithstanding Clause, formerly known as Section 33 of the Canadian Charter of Rights and Freedoms. This provision of the Charter, which allows Canada's federal and provincial governments to derogate from some of the key provisions of the Charter human rights commitments, has been invoked with unusual frequency in the last half-decade, ending a period of its relative dormancy. In light of this shift from the clause's dormancy to activity, the 29th November event addressed a set of insistent questions about how political and legal actors might navigate the changing landscape of rights protection in Canada, including questions about the types of legal arguments and political action that might be deployed in response to more concerning uses of Section 33 in the coming months and years. The speakers today are Senator Peter Hader, Professor Earl Mendes, University of Ottawa Faculty of Law and President of the International Commission of Jurists Canada, and Professor Stéphane Bollac, Université de Montréal, Faculté de Droit. Following short presentations by the speakers, there will be time to address questions. Please.
Thank you very much. One of the things I want to start with is by presenting the views from the University of Alberta. And one of the reasons why it was critical that we have the University of Alberta presenting their views is that they were keen to present one of the architects of Section 33, who is often not really discussed very much in the media, with all the discussion on Section 33. I'm talking about Premier Lougheed, who was there at the creation of Section 33 when he was in favor of it, but his strong position, and he basically made this clear in his presentations to the University of Alberta in the 1980s. I was there as a former law professor from the University of Alberta, when he basically stated that even though he was in favor, he was very insistent there should be political accountability for any use of Section 33. And the way he presented that was that, first of all, he was strongly in favor of not using a preemptive use of Section 33, which means that you would be preempting the judicial branch to making its view on whether or not a Section 33 clause is justified. And he basically felt that that was a precondition of him, a conservative premier, from essentially accepting the notwithstanding clause. He also went on to say that, in his view, this notion of political accountability meant that there should be a majority vote in the legislature before it is used. Now, what's really interesting that his views actually carried through into the public in Alberta. And keeping in mind that he was a conservative premier and subsequent premiers were conservative, like conservative Ralph Klein, who used Section 33, but because of the backlash from the media, political society, on two occasions, firstly dealing with the compensation for sterilization, and secondly dealing with his attempt to basically prevent the move towards same-sex marriage, the backlash led him to back off on that. So what the University of Alberta did in this presentation was to present, if you like, the views of a Conservative Premier. And given the fact that we have the potential for a future Conservative Prime Minister who says he or she will use the clause very much, gives you an indication that the creation of Section 33 was very much driven by a Conservative view that there should be political accountability for the use of such a clause, which meant to not have the preemption use of the clause, and secondly, to have at least a majority view of it. So this was the views of our colleagues at the University of Alberta, who was very keen to present that view of the origins from Alberta of Section 33. So moving on then to the views of my own university's presentations on that, we built on that to point out that where the most recent invocations of Section 33 on 3 occasions by Premier Ford really showed that what was at stake was not really the sovereignty of legislatures to override judicial decisions which may be overstretching the views of the judiciary, but in fact what was happening in effect was an autocratic intent by the executive on 3 occasions. Firstly, when dealing, for example, with the use of the Section 33 clause in terms of seizing down or scaling down the wards in Toronto from 47 to 35, when because a Superior Court judge basically said, you can't do that, it's in violation of the Charter, Premier Ford immediately brought in Section 33. Now, eventually, that was allowed on appeal, and ultimately in the Supreme Court of Canada, that too was allowed. But I want to stress what happened in the Supreme Court of Canada was very significant, that even though a majority allowed the use of Section 33, a strong dissent said that there were unwritten principles of the Constitution which would invalidate that legislation. And the ones that they stressed, most important, was the democracy principle, the rule of law principle, and the protection of minorities principle. So that gives you an indication that in the Supreme Court of Canada, there are potential limits to how the clause should be used. Again, to go back to Premier Lougheed's view, there has to be some accountability for the use, excessive use of the clause. Nevertheless, Premier Ford went on to use it twice again. One, again, in terms of trying to limit the advertising by his chief adversary, the unions, by extending the period by which they could not give compensation. Yet again, that too went all the way up to the Supreme Court of Canada. As an intervener in the Supreme Court of Canada, again, the International Commission of Jurists tried to stress that because what was at stake in that case was the Section 3 right, the democracy right, was that there should be a very strong interpretation by the court to stop the use of the Section 33 to undermine non-derogable rights. We are waiting for that decision, and we hope that the Supreme Court of Canada will give you some indication that they too will have some concerns yet again with Section 33. And the final one, which is obviously one which we had in some respects, not so much the sovereignty of the legislature being in play, but the sovereignty of the people. When again Ford used Section 33 to stop a potential strike by the lowest paid workers in the education sector. And he threatened to use of it and did use it, but because the workers and a very strong majority of Ontario's population basically had a backlash against that, he finally backed off. So what does all this say? It basically says that yet again, the most recent use of Section 33 is a fundamental lack of political accountability, fundamental lack of the promise by a Conservative Premier, Lougheed, that there should always be checks on the excessive use, such as, for example, preventing the preemptive use, and secondly, at least giving an indication for the public to have some say in the use of a clause which potentially can undermine still the most important constitutional document that the vast majority of Canadians still consider as a critical part of the Canadian Constitution, the Canadian Charter of Rights and Freedoms. So in the end, we in Ottawa basically stressed that going back to Premier Lougheed's view that there should be political accountability and safeguards, we are suggesting that in addition to the points we made, that we teamed up with the Canadian Bar Association, and they, together with us and some of us working with the Canadian Bar Association, presented a letter to Minister Virani, the Justice Minister, to suggest that there should be critical guidelines in the future use of Section 33. And let me spell them out. Firstly, they again should be a prevention of the use of the preemptive clause. Secondly, there should be a majority vote. Thirdly, there should be a large amount of public discussion, possibly through the use of a preamble, which allows more discussion in the legislature to therefore give some semblance to the idea of legislative sovereignty as opposed to executive autocratic responsibility. And then finally, like the others, we too agree that there should be some way in which there should be, for example, a charter compliance review by the Department of Justice before there is a formal presenting of a Section 33 clause before Parliament. So I'll leave it at that, and I'll pass it on to my colleague who was in charge of the University of Montreal's presentations.
Merci, Harold.
Thank you very much.
Alors, l'événement,
This event with the universities of Ottawa, Montreal, and Edmonton focused on a call to action in order to have more debates on the matter and to try to speak with civil society so that it might be more interested in files that are often summarized too simply as goodwill and issues of rights and freedoms. We wanted to look at going back to the source. One must understand, if you're interested in the notwithstanding clause, well, it focuses on basic rights. And with the Universal Declaration of Human Rights, it is essential. In Quebec, we have a charter, and in Canada, we have the Canadian Charter. But beyond these legislative texts, these are things that are intrinsically linked to being a person. The Ford decision from '84, unfortunately, is sometimes considered, especially in Quebec, but also elsewhere, as being untouchable, as though a single decision could cover all aspects of the notwithstanding clause. And this happens with complex matters regarding the Canadian Charter of Rights and Freedoms. And if we're talking about charters, with both the Canadian Charter and the Quebec Charter, there's usually a series of decisions that clarify applicable tests. And we believe that that is essential in the current context of an increased use of notwithstanding clauses. It shouldn't be used to radically change the way we understand Section 33 of the Canadian Charter and 52 of the Quebec Charter. And as my colleague Mr. Mendes mentioned, we should reevaluate the role of the courts as guardians of the Canadian Constitution as the rule of law, and whether or not they should require more and go beyond the simple matters brought up in Ford 84. We're not talking about reversing it, but to analyze things further regarding the Canadian and Quebec charters. Reviewing the interpretation of Section 33 must come with adjustments and it's been needed since 2020 with how they are revised with Poulain Quebec Inc. and the City of Toronto. We continue to focus on the goal. What is the goal of the clause? In this case, Section 33. When we look at Section 33 in context and what it seeks to achieve, and especially if we look at this with the Charter, we need to understand that 33 is an exception to confirm the rule, which is to protect human rights in Canada. When we keep that in mind, it validates an interpretation that will maintain the role as a guardian of constitutional rights, and so the courts should act and require more than what jurisprudence in the country has suggested. And two final things. International law validates such an interpretation. We can talk about globalization, constitutional rights, but using international law is being more and more commonplace and should be the case for the reinterpretation of Section 33 regarding two standards, the one to access to justice and that's what we need to understand. Secondly, for redress, we need to ensure that Canadians have access to justice when their fundamental rights have been infringed upon. And lastly, in current context, regarding Indigenous rights and constitutional rights, I would like to highlight a recent case of the Supreme Court of Canada from 2024, which validates the idea that courts should be involved in decisions that could lead to limits, restrictions on rights and freedoms. We looked at Section 25 of the Canadian Charter, which protects Indigenous rights, and the Supreme Court of Canada in that case clearly maintained that role as a guardian of the Constitution and protected one of the most fundamental rights in the way to govern in a constitutional democracy such as Canada. And it's the matter of the rule of law. And again, it is the court's responsibility, and that should be their constitutional mission. And so that's a way to summarize the key takeaways from the panel hosted by the Université de Montréal. Thank you.
Just before we hand over to Senator Harder, we were very pleased that Senator Harder agreed to come and present his views at the University of Ottawa's event. And for that, I'd like to pass over to Senator Harder to give what he said at the conference, which I think was very much strongly supported by everyone else from the three universities.
Thank you very much, Professor. As has been made clear, the notwithstanding clause has never been used at the federal level in 42 years. And yet, last spring, there was musings from the leader of the opposition at a speech that he gave before some policemen that he would consider invoking the notwithstanding clause in federal legislation. I was very disturbed by that and thought that there would be, frankly, a public reaction of some note, both politically and from social media, and was disappointed that it seemed to go unnoticed, almost because there has been a normalization of the practice based on the provincial experience that has been referenced. So in May of this year, May 23rd, I tabled a motion in the Senate outlining how the Senate should react should a notwithstanding clause bill be introduced. I spoke to that motion in September 24th, and I'd like to just highlight how I believe a Senate should act, and frankly, how I wish a House of Commons would act, because it is in many senses on this matter a chamber that ought to consider the Charter of Rights and Freedoms in a very focused fashion. So here are the principles. One, there would be no preemptive use. That has been described already in this panel, and I won't detail it. Second, that the Minister of Justice, as the Minister of Justice does for all bills now, table a charter statement, which would very clearly have to indicate what are the charter implications of the bill being proposed. Third, a commitment by the government that there would be no time allocation used in the consideration of this bill in the Senate, and I hope in the House of Commons. And four, that there would be, as a result of that, appropriate hearings to hear from experts and those affected most by the proposed bill. This would ensure that there was an appropriate dialogue and public engagement, because as the founders of the notwithstanding clause felt, that this should be a very rarely used instrument that should not undermine the Charter's provisions. A lot of talk in the last while about parliamentary supremacy versus judicial supremacy. And the founders of the notwithstanding clause very much were on the parliamentary supremacy side with a price. In other words, there was the 5-year limit and the engagement with an electorate. I would like to suggest that with the approach I'm outlining, that we would be reinforcing neither parliamentary nor judicial supremacy, but constitutional supremacy. Because that, after all, is what this is about. How do you engage in a dialogue with Canadians when their rights are being removed by the very government? And I worry, frankly, about populist authoritarian governments undermining the whole charter, which so many Canadians view as a defining instrument of what it is to be Canadian. Thank you.
Thank you very much, and we're open to questions now from the media.
Thank you. I'll ask our participants who are online to please use the raised hand function on Zoom if you have a question. I don't see any online, so I'm going to use my moderator's privilege to ask one, if that's okay. When we talk about accountability for the use of the notwithstanding clause, doesn't that ultimately belong in the hands of voters? I mean, Saskatchewan, the government there was re-elected. Doug Ford's been re-elected. Bill 21 is very popular amongst Quebec voters. Shouldn't that be the ultimate check against for voters to have the say in whether they approve of this or not?
Actually, go ahead, yes. Yeah,
I'm
go ahead.
prepared to
yes,
say
yeah.
some stuff on it. We live in a democracy. Of course, voters have an important role to play, and it was designed in the instrument itself. My concern is that the use of the notwithstanding clause is politically achievable when you're dealing with the least able to defend themselves in the court system. And that is a worry. And I think it's to the credit of governments of all parties at the federal level not to have contemplated the use of the notwithstanding clause, even in the face of the rejection of legislation that they otherwise would have favored. So I understand your comment about the discipline of the electorate, and it's provided for. But if you are concerned about populism running roughshod over individual rights, particularly of those who are less able to defend themselves, I think we've got a real serious problem.
And can I add to that? One of the things that is often forgotten is that the reason why we have a Charter of Rights and Freedoms was that after the end of the Second World War, there was an agreement by Canadians coast to coast to coast that we had to show that we are in agreement with what was being developed at the international stage, which was the Universal Declaration of Human Rights. Often forgotten that a Canadian was one of the drafters of the Universal Declaration of Human Rights, John Humphreys, a former professor at McGill University who became the director of the UN Human Rights Commission. And Pierre Elliott Trudeau basically picked up on this amazing feat by a Canadian, but by the whole world, to have a document which would basically say, in a democracy where you are committed to these fundamental rights, the views of majority cannot always prevail. That ultimately there has to be ways in which you can have rights which are protected by some means whatsoever. We decided in 1982 to have a Bill of Rights which then would be protected primarily by the judiciary. Yes, we decided that there would be legislative supremacy through the use of the Section 33 clause. But before that would happen, there would be some form of accountability, as Premier Lougheed said, should be in place, such as not having the preemptive clause to allow the courts to rule on it, and secondly, to give some indication that within the legislature itself, you're talking about voters. Well, what about the majority of the legislature itself to have a vote in the erasing of the rights? And then finally, I can point out to you one thing which happened with Premier Ford's use of the notwithstanding clause, when he basically was going to use the clause to stop the strike by the lowest paid education workers in Ontario. Think about what would happen if he had gone ahead with this. That essentially by not giving them the right, yes, ultimately he may have essentially been re-elected, but what would happen to those voters, those workers? What sort of democracy would they see happening in Ontario when their rights are being completely erased? So I'm talking about voters, yes, but think about which voters which would be susceptible to the autocratic use of Section 33. Do you want to add anything?
Oui, je vais ajouter. Bon, on est prof d'université, alors on est là pour donner un...
We can give a perspective as academics. We can look at the post-war time, and I made reference to the Universal Declaration of Human Rights, which was given more details so that it could protect what is inherent to human rights. Some might think that human rights are a gift that representatives of populations offer, but no. With Section 33 and the notwithstanding clause and Section 52 for the Quebec Charter, these measures exist for a reason. West Valley Peace from 1648 that put an end to the 30-Year War, which is often seen as at the heart of international law, but also saw constitutional documents, and with West Valley, it sought to protect religious minorities, and because the prince had a different religion. That's constitutionalism. That doesn't come from 1982 or Pierre Elliott Trudeau. It comes from long before the Universal Declaration of Human Rights. And I'll come back to your question now. History shows that the majority can decide to protect the rights of the minorities, but that doesn't necessarily work. And we need a balanced way of doing things. We don't want one extreme or another. In 1982, for those negotiating, they thought that Section 33 might help find that kind of balance. But 45 years later, we're seeing that that balance has been broken. There's an excessive use of Section 33, not only in my province in Quebec, by invoking links to the Quebec identity in order to have the support of Quebecers, and in other provinces, and we heard a lot of talk about Ontario, but this is happening elsewhere in the country as well. There's an excessive use of this notwithstanding clause, and it can short circuit what has been working quite well since '82. And we want a call to action to get back to the source. And we want to focus on protecting fundamental freedoms, which is essential to human rights. We need to remind the Premier of that, and the Prime Minister and his Minister of Justice. And also a reminder to François Legault and Mr. Barrette in Quebec.
Thank you very much to everyone.
Thank you.
Attention, Canadians. Do you feel disconnected from our current political system? This could be our last chance to take a real legal stand for our rights. It's time to shift the political power to its rightful owners, the Canadian citizens and Indigenous peoples of Canada. Dive into our history, understand the need for change, and embark on the quest for true democracy. Are you concerned about our nation's commitment to human rights and self-governance? The power shift to freedom aligns with vital treaties and international laws enabling us to claim our rightful place as collective head of state. We advocate legally replacing the Crown, King Charles III, and our partocracy system with a true democracy, the peoples as the true collective head of state with veto power over our governance, to ensure your voice counts more than party interests. When our national collective civil and political rights are respected, your influence on policies will be direct and impactful. Join us on this noble struggle to make every Canadian and Indigenous peoples a meaningful participant in our future as collective head of state, which was legally owed and kept from us since the patriation of our Constitution, an official decolonization from the United Kingdom of 1982. It's time to correct the past of our government's lies and omissions to the people of our great country before it is too late. People 15 years old and over can sign our Canadian People's Referendum at canadianreferendum.ca and unite for our rights as the collective head of state in our Constitution. Together, we can be the example in reshaping Canada's future, not just for us, but for all peoples worldwide, once and for all. Are you ready to be part of this transformative movement? Join the Power Shift to Freedom movement by the Canadian People's Union and be part of a bold vision for Canada's future. Visit thecpu.ca for more details. Embrace and face the change required on your part to shape our future.